Hi there, I'm Jemma Garside. I'm a solicitor in the Community Care Department at Boys Turner. My colleague Julie Marsh and I had planned to run a training day in March this year for social workers talking about life after brain injury. We had a great lineup with lots of wonderful speakers who were going to come and speak about some of the issues facing young people. Unfortunately, due to the pandemic, this had to be cancelled, and it seems that we won't be able to put this on anytime in the near future. So we've taken it online and we're running a series of webinars. Today I'm joined by my colleague, Rachael Allison, and she's going to talk to us about some of the issues facing young people after they've had a brain injury with education. She's a specialist here as an associate solicitor in our special educational needs department. Hi Rachael, thanks for joining me.
Many thanks, Jemma, for that introduction, and thank you for inviting me to join the training for social workers. Before we actually start our talk, I would like to make a special mention to a group of local social workers who have been instrumental in helping us create this course. All the questions raised today are your questions, and I hope they assist you with production of future EHCP'S and supporting children and young people in your area.
Great, and thank you to the team. So let's start at the beginning, Rachael. What is an EHCP?
An education healthcare plan is something that supports children and young people through their educational journey, potentially supporting them up until the age of 25. Education healthcare plans were introduced via the Children and Families Act in 2014. And the ethos and the thinking behind them really was that the local authority and all commissioning groups, that's health and social care, joined together in order to produce some form of holistic approach to the support of children and young people. For the purposes of this talk, young people are those aged 16 and above. The Children and Families Act goes on to define a child or young person as having special educational needs if they have a difficulty or disability that requires special educational provision to be made for them. So that's essentially a difficulty or disability that places them at a significantly greater difficulty in learning or accessing learning than the majority of their peers. Each local authority has their own format for an education healthcare plan. So you might find that the body of the agreement differs from local authority. Essentially, it's divided into a number of sections from A through to K, A being the parent and child view, sections B and F relating to special educational needs and the provision to meet those needs. C and G relate to health needs and provision. And your section, the one that's going to introduce you, going to attract the social worker input, are sections D and H. And H is divided into two sections, which I'll expand on later. I looks at placement, and K is appendices. That's all documents that inform the content of the plan. These plans, once they're produced, are reviewable annually.
So why did the law change, and where does social care fit in?
Previous to educational healthcare plans, there was something called a statement, and that supported a young person until about the age of 18. The education healthcare plans have obviously been extended to support children and young people until the age of 25. In 2018, something called a national trial was introduced that essentially sought to expand the powers of tribunals as to the orders and recommendations they can make in a tribunal appeal. The position currently is that an order, a binding order, can be made in relation to education needs and provision. With regards to health and social care, a tribunal panel can now make recommendations, and the assumption is that those recommendations will be followed through. If they're not, they are going to be subject to further scrutiny by ultimately the Secretary of State, and the national trial appeal is going to be subject to ongoing review. The next review is scheduled for August 2021. I think the implication is that if these recommendations are not followed, then possibly the powers of a tribunal will be extended to binding provisions as they relate to social care and or health. These powers were extended under the Special Educational Needs and Disability First Tier Tribunal Recommendations Regulations of 2017. And the thinking behind it was that essentially the education tribunal system is one point of call for the parents to have addressed all issues relating to their child.
So Rachel, my understanding would be that part of the plan where you're required to show the social worker's assessment would simply include a Section 17 assessment that's completed and for a child in need. Is that right? What should be included in the social care assessment?
Basically, I think look at the plan that is currently being drafted. Often you're given a draft at this stage. But also refer to the legislation and regulations, which will really point you in the direction of what really needs to be inputted into the plan. Firstly, looking at your education healthcare plan, obviously Section D will need to relate to social care needs related to SEN, and Sections H are divided into subsections 1 that relate to children or young persons under the age of 18 that fall within Section 2 of the Chronically Sick and Disabled Persons Act 1970. And you will need to ask yourself the question, does your particular child fall under the definition under the Act? And if they don't, then obviously fall to Section H2 and specify within H2 any welfare services that you think the child requires by reason of their learning differences or disability. Another excellent reference point is the SEN Code of Practice, particularly paragraphs 9.69, which detail the suggested input that can go into sections H1 and H2. Finally, if the local authority has either been ordered to make an assessment or of their own volition have decided to assess a child following a request from the parent for an education healthcare assessment, then refer to the Special Educational Needs and Disability Regulations 2014, particularly subsection 6, where it lists the assessments that a local authority must undertake as a part of their duty to assess in this case. So essentially, you will look at the advice and information from all other providers as well, share your resources and share your information with other commissioning groups. That's the whole purpose of this plan. But you will need to look particularly at subsection E to know essentially that that's where your duty arises. And if you've got any problems with panels, just refer them to this legislation, that this is your duty and this is how you should be reporting into your case. Finally, you might also want to be aware that there is a budget available to local authorities to assist in the report making process. I believe it's in the region of £4,500. Finally, obviously be aware that where a young person is over 18, then obviously legislation also applies for adult social care, which Jemma has alluded to.
Those transitional years are really important, so I think we'll discuss those a bit further later on. But my next question is, does a social worker need to provide evidence of how support and services are going to be provided?
I think the answer to this question is probably more of a practical basis. Just bear in mind that when you report for the purposes of a plan, you'll be needing to look at needs and then provision to meet those needs. The question of how that support is delivered really isn't something for a plan or shouldn't be a concern of parents, but my view is often it helps, certainly with those picking up a plan for the first time, to understand fully to whom they may address support needs and where they can get information and the support required in order to effect proper delivery under the plan.
So What part of the plan should a social care occupational therapist write?
This is a tricky question. Which part of the plan should a social care OT specialist contribute towards? Again, I think, alluding to my previous response, it's supposed to be a holistic approach to plan creation from all commissioning groups. I guess under social care, your duty will be really looking at social care needs and provision. But where they overlap slightly with OT, then you might want to comment on health as well, although I would suggest it's probably a direct input from NHS appointed OT in any event. Be mindful, however, of Section 21(5) of the Children and Families Act, which states that healthcare provision or social care provision which educates and or trains a child or young person is to be treated as a special educational provision instead of healthcare provision or social care provision or otherwise health, and fall therefore under sections B and F of the plan. Now that will only really become apparent as you assess the child or young person. You also might want to think of issues such as waking day or life skills that occur after standard school hours, and again, whether they educate or train a child, and we would argue therefore that it's likely to fall under sections B and F of the plan. It very much, I think, depends on the circumstances of your case and the evidence that arises.
So the next question we've been asked to put to you, Rachel, is a bit of a tricky one, and it may be that you can only give a little bit of guidance here, but do you have any tips to get through a panel?
The next question is really impossible for me to answer, as I'm not an employee of a local authority and I'm not really aware of the boundaries and costings that probably attach to panel decisions. The basics, however, really are to look at the legislation, the regulations, and the SEND code of practice. And if you come across any buffers with your panel, perhaps refer them back to their duty under the legislation. You've also got to make sure that you don't end up in breach of any orders of a tribunal. If a case has started and there's a specific order that requires a social care report to be produced as part of the hearing, then you certainly don't want to be in breach or worse, contempt for not complying with any orders of a tribunal. Also bear in mind that as an expert, your primary duty is actually to the tribunal, not even to the child or to your employers. Your duty is actually to the tribunal in these circumstances. Another point to note is that if your report is not fit for purpose or is light on its information, then it's highly likely that evidence from your opposite side is likely to be preferred and orders granted on the basis of either an independent social worker assessment, as has happened in some of the cases that we have run, or indeed a case manager with occupational therapy experience who was also able to comment on social care needs, and her recommendations were supported by the tribunal.
So our next question that we were asked was about equipment, and I'm sure that, again, there might be a couple of different answers here, but who should pay for equipment?
Who should pay for the equipment? That very much depends on what the evidence says. Also remember that as a group of commissioning groups, you should be working together to ascribe and share costs between you. It's ultimately one local authority that will be paying for everything under this education healthcare plan. Also bear in mind the legislation under section 21(5) of the Children and Families Act. So if the equipment is going to be used to educate and train a child, then it's probably going to fall under the education department under sections B and F. If perhaps it's equipment or aids in relation to purely physiotherapy needs, then it might well fall under health. Obviously, some social care support can extend into access to activities, community groups, but it really does depend on what the evidence says as a whole, and that's all the evidence related to the case.
But in general, who pays for a residential placement in a school?
Again, look at the evidence, and that now could be evidence extending to your educational psychologists, as well as therapists, as well as your social care report. Is a waking day placement required? Are life skills required beyond school hours? You can have the needs of a waking day placement, and that absolutely falls under education, under sections B and F, and falls payable, I think, by the education team. However, if your placement is split into both educational and residential needs, then it obviously follows that the funding of that placement might well be split between education and social care. Note that a child can be accommodated under Section 20 of the Children Act 1989 as a child in need, and education legislation within a residential specialist educational setting. Both sets of legislation can run alongside each other, and there is case law now to support that application.
Just to add from my perspective that social workers should be mindful that where there are young people in residential placements, where they're about to reach the age of 18 and they're receiving some funding from social care, sections 58 to 66 of the Care Act 2014 would kick in, and there would need to be an assessment by adult social services to take over the funding of the social care element of the package. As you know, Rachel, the Code of Practice does say that Care Act provision can still form part of an EHCP after a young person has turned 18. And that's something that we think social workers might need to be mindful of. My next question to you, Rachel, is what happens once the tribunal have made any recommendations about health and social care?
Well, for social care in particular, the local authority will be sent a copy of the decision. They must respond to the parent or young person within 5 weeks in writing, confirming what steps they're now going to take in response to those recommendations, and give the reasons if they're not going to follow some or all of those recommendations. The local authority then needs to send a copy of its response also to the Secretary of State. If it transpires that a local authority is not going to comply with the recommendations of a tribunal, there are other points of redress, such as a complaint to the local authority or the CCG through their respective complaints processes, or it can be escalated up to the legal government or social care ombudsman, and ultimately over to judicial review.
So finally, Rachel, is there any evidence that social care input has been of use in EHCP'S?
There is good and bad news here. The SENDIST Tribunal have user group meetings held throughout the year, and figures from the last group confirm that there have been 2,500 national trial appeals. The original estimates were only for 200, so obviously there's a huge influx of cases in this area, which suggests that health and social care are genuine concerns of parents and young persons out there. The scheme's obviously now been extended to August 2021, where further feedback will be provided. The bad news for social workers is that there have been fairly negative feedback regarding the social care aspect of the tribunal system. Healthcare recommendations have generally been followed through without any reports of any problems. The problems encountered with social care has either been perception that social workers and teams are not cooperating, or that they don't provide sufficient or enough information, or that information is provided too late. Orders can be made, obviously, for social care assessments where they haven't been undertaken throughout the normal process of assessment at the beginning of a case. That's under Regulation 6. There are also issues with regards to requests for direct payments from parents, also complaints about respite support and access to community activities. Essentially, the advice is therefore to look again at Section 2 of the Chronically Sick and Disabled Persons Act and readdress Sections H1 and 2 of your plan to make sure that the reports that you are writing can properly inform those sections of the plan. The biggest area of dispute has been in relation to young persons, particularly where they transition from child social care support into adult social care support services. The young adult group in particular, 18 to 20s, where there's actually a dual social care duty under social care legislation, but also arising under the Children and Families Act. And I think that's where the confusion has arisen in these cases. As I've said before, there is case law to confirm that the legislations in each of these genres can act alongside each other. And I think the complications and misunderstandings as to that situation probably need to be further understood and properly applied in order to iron out the problems that are currently faced. I hope that's given everyone a basic idea of the legislation, regulations, and the SEND code of practice that's applicable to you in these cases, and that can help you formulate more thorough reports for ongoing practice in this area. If you require any more information and support, then just do ask. Thank you.
That's great, Rachel. Well, thank you so much for talking to us today. And just to say to everyone out there, if you have any further questions, or even if you want Rachel and her team to come and give some further training, please do get in touch. And we hope you all stay safe and well, and hopefully maybe see you soon.
Many thanks.